All right, we continue to look at today's court proceedings and the application to interdict the sitting of the JSC next week. We're now joined by legal analyst Mpumelelo Zikalala. Good afternoon, Mpumelelo. Thank you very much for joining us on the program. You know, I'd like for us to be a bit thematic in how we go about unpacking today's proceeding. So as a start, let's deal with what the case is about. Advocate Hlophe was quick to say his opponents were making two fundamental mistakes when it comes to what the case is about. He said it isn't an attempt to re-argue the Western Cape High Court case in the form of a backdoor appeal, nor are they raising the same points as those they raised in the Western Cape High Court. For instance, they wouldn't have sought a postponement of the JSC sitting because the JSC had not taken a decision. What are your views on just these aspects?
Good evening to you, good evening to your viewers. Well, at the end of the day, the same points would have been argued, but I think in this case, I would have concentrated mainly on the element of agency. Two very important points. Irreparable harm, which is going to be suffered by Dr. Hlophe if he does not attend, or if the meeting of the JSC goes through. The other one is that an alternative remedies that are there, according to him, that could be explored by him in order for him to enjoy his rights. If you would have listened to Advocate Hlophe carefully, he was quick to then say the rights in which was seeking to protect him are that of Dr. Hlophe being able to participate in parliamentary processes as a member of parliament. If there are certain things that cannot be achieved by him because he has been told that he cannot maneuver or sit within a meeting of the JSC, then the meeting must be postponed so that he can be able to participate. What can't be done is that you can't do the meeting which is going to, or the interviews which are going to sit next week. So in that case, according to him, he is going to suffer irreparable harm because he won't participate in the process. However, there is an existing interdict that exists that says for an interim basis, you are not allowed to do that. Now, the problem which is going to be found by the court is that it can't act as a court of appeal within the same division. So they can't say we are going to ignore the interdict that has been issued and simply say go and say to the JSC, don't allow this interview to sit because there's some technical flaw that is going to be there. Especially when you put it how the
Pardon me for interjecting there, which is something that at one point the judge crystallized, that when they had the back and forth with Advocate Hlophe, that the question is whether the JSC responded lawfully and rationally, and they must all recognize that the JSC cannot go against the order of the Western Cape High Court, nor can the Johannesburg High Court itself at this point. So meaning they somehow have to operate within the ambit of the law, whatever they can do, but they cannot go against the High Court judgment in the Western Cape.
And what the JSC would have concentrated on would be to say, are we going to be constituted effectively on properly or legally in order for us to, for all the decisions that we are going to take to be legally binding, whoever is going to sit in on those interviews. Now you go back to what the Constitution is saying. It says, here are the members of the JSC. The Chief Justice is there. The President of the SCA is there. The Provincial Division Judge Presidents are there. The President designates are there from the law profession, the professor, and Parliament. Now let's concentrate on Parliament for a while. It then says within the parliamentary delegation, at least 3 must come from opposition parties. Whether it is not clear that it's 3 from an opposition party of a single party or 2 of them, but if it's 3 or more, then it's properly constituted. And if they vote and the majority vote says that we want these individuals, then that meeting is properly constituted, it can be able to continue. So the argument of saying that there might be legality which is going to be raised at a certain stage, it's something that can be debated on another time.
But it seemed it was dispensed with. It seemed it was dispensed with because even Advocate Hlophe stated there that insofar as the absence of Dr. Hlophe, it would not vitiate the process, that it would still go ahead because ordinarily somebody can be absent. So again, they were still belaboring the point that it's his Section 19 rights that would be violated in this respect, his absence.
But now we must then go back and say, in the application of the Section 19 rights, which is politically related, remember Dr. Hlophe has not been voted in as an individual. He's been voted in as a part of a political party. So the seat which is allocated within the JSC is allocated to the MK Party and not to an individual. So it's up to the MK to then decide who are we going to deploy in this particular position so that you can be able to continue. So if the MK is of the opinion that because Dr. Hlophe, you are barred from engaging in this sitting, let's get someone else to fit in your position so that we have a view that who the future presiding officers are going to be. They have a prerogative in terms of doing that. And the most important part of that is that there's an alternative remedy which can be utilized by the MK MK Party that is voted in Parliament is accountable to the people that how it conducts itself in Parliament. So in that basis, it then sort of weakens the argument of Dr. Hlophe to then say, if there's an alternative remedy or an alternative to you or compared to you, then the element of urgency falls away. Even if we look at the merits, which are still going to be decided at a later stage, it doesn't matter to you anymore, because purely on the element of urgency, the matter ought to be struck off the road. But I think it's something in which the judge is certainly going to focus on tomorrow to make sure that we all understand it, how it arrived at his decision.
And then just before we close, I want us to look or unpack or share or get your views on Advocate Ngalwane's argument. I listened attentively as he took the court through the argument of a possibly wholly tainted parliamentary process in the appointment of designates to the JSC. He said if it's maintained that Parliament failed to appreciate that it has a discretion in the appointment of Hlophe, then it naturally follows that Parliament would have failed to appreciate that it also had a discretion even in the appointment of the other designates, because Parliament has followed the same convention over the years. A party raises a name, they simply accept. So what did you make of just that statement of possibly the whole process being tainted?
Well, it is a valid argument and the one which must be explored, but it would be better placed when they are dealing with part 2 of the application against Judge Hlophe, because what you then do, you go a step further and then you say, on what basis or which legal provision does the Speaker has a discretion of whether a person should be appointed or not? And in what instances is the Speaker going to allow that discretion to apply? And what are going to be the rules and the elements which are going to be looked at when the discretionary process is being utilized? So for me, it was a good argument, but it is not an argument that should have been raised today. Maybe it is an argument that can be perfectly placed when part 2 is being argued. And it's going to be very interesting to then see how even the courts are going to maneuver around that particular fact. I would have thought that when the court was issuing the first order that issued the interdict, it was not going to detail as to why they're arriving at that particular decision. It will simply look at the elements of urgency and end it there, because what now they have done is that they've given us a glimpse as to what exactly they're going to look for. And the problem with that is, where is the legality of it all? In which section of the Constitution, when you read it, it's going to say, Speaker, you have a discretion whether the person serves on this particular committee or not, because if you start to do that, you're opening up a can of worms.
And Dumseli Ntuli of the ANC had said, according to him, there's a lacuna in law when it comes to this specific case, because it's quite frankly new. But thank you very much, Mpumelelo, for your time. Unfortunately, we have run out of time. That's legal analyst Mpumelelo Zikalala speaking to us.